And our first speaker, and our speakers can come on up as I'm introducing you, is Professor Theodore Sims, who is a professor of law at Boston University School of Law. Following graduation from the University of Chicago Law School, Professor Sims clerked for John Godbold, thank you, of the U.S. Court of Appeals.
With an Alabama accent.
Okay. At the Court of Appeals for the Fifth Circuit. He practiced law in D.C., and he served for 4 years at the U.S. Treasury Office of Tax Policy. And since leaving the Treasury, he has taught full-time for the past 15 years at BU. At the Treasury, his areas of responsibility included the range of issues relating to tax-exempt organizations, including the charitable contribution deduction. As such, he was responsible for helping to formulate the Treasury's position and preparing testimony on the legislation that eventually became Section 170H, our deduction provision. Before leaving Treasury, he was involved in the initial stages of drafting the regulations under that provision. He holds a PhD in economics from MIT.
Thank you, Nancy. In contrast with most of the people in this room, this is not an area in which I regularly work. Loath though I am to admit it, it has been 30 years since I worked in this area, more than 30 years actually. And I think I was Nancy's second choice to sort of fill the role that I'm fulfilling today after one Dan Halprin, who is a professor of law at the Harvard Law School, somebody for whom I worked back at the Treasury in the late 1970s and early 80s, between the time when the initial version of 170H was enacted and the legislation became permanent in 1980. I have to say, since I'm not somebody who works in the conservation easements area, I'm probably going to serve the role of the scourge in the room today. It's a role that I fulfilled once before at the invitation of an individual whose name many of you may know, was somebody named Kingsbury Brown, who was sort of the leader of the people sort of trying to secure reauthorization of this legislation. And in late 1979, he invited me to a meeting at the Brandywine Conservatory. The Treasury said, go ahead. I prepared some remarks. I mention it today because when I got to that meeting, I was given a ride to the Brandywine Conservatory from the local Amtrak station by an individual whose name was Ed Copeland. It was about a 20 or 30-minute drive, and so we fell into a conversation about conservation easements. And being somebody who worked for the Treasury, I asked what was a standard question for somebody from the Treasury, which was, why do you need a tax deduction? Why don't you just appropriate funds and buy conservation easements? And Mr. Copeland's answer was, there isn't any money to buy conservation easements. That's why the tax deduction is so important. That was his answer then. I sort of used it in my remarks to the Brandywine Conservatory. And I suspect if I asked the same question to people in the room today, they would sort of give essentially the same answer. That sort of raises the question of what it is that's sort of special about tax deductions for conservation easements. So as everybody knows, Congress did ultimately make Section 170H permanent. What everybody may not know is that they did so over the objection of the Treasury. While I didn't take a position when I spoke at the Brandywine Conservatory, eventually Treasury came out and opposed the legislation. All right? Since most of the people in this room will be of the view that tax deductions for charitable contributions are a good thing, it's sort of reasonable to ask, well, why is it that Treasury would have opposed something that seemed to have such laudable objectives? So what I want to do is sort of take 7 or 8 minutes, it'll get a little bit technical, I hope not too much, to sort of outline what the nature of the concerns was that animated Treasury back in 1979 and 1980 to oppose the legislation. I want to say that I do all of this without taking away in any respect from the validity, the legitimacy, and the importance of the interests that are served by people who are interested in the conservation of open space lands and things of that sort. People who work in my field take that objective, the legitimacy of that objective as a given. So the question is, what is it that makes it appropriate, and what is it that caused Treasury to object to the use of tax deductions to encourage this activity? Okay, so the first thing to keep in mind, and it's implicit at least in what Nancy had to say, is that when you encourage the contribution of conservation easements through tax deductions, it is not something that is happening for free. That is, even though nobody is ponying up money, somebody is paying a cost. That cost is hidden, and the cost takes the form of revenue foregone by the Treasury. So one thing that you have to recognize is that when a tax deduction is allowed for a charitable contribution of a conservation easement, somebody's paying the cost. The person that's paying, not the person, but the organization that's paying the cost is the federal government. And implicitly, the people that are paying the cost are the rest of the tax-paying public, because revenue foregone from the contribution is revenue that has to be made up from someplace else. Okay. Now, that's not peculiar to conservation easements. That is true of contributions, charitable contributions generally. So it's not something that raises a special objection to conservation easements. The second issue, and I think this is important and not adequately understood, is that there is something especially high-powered about incentives, many of the incentives for charitable contributions, and it comes from what I call the appreciated property rules. And in simple terms, it works like this. If I buy a piece of land, undeveloped land, and I hold it for a long period of time, I'm not going to be taxed on the unrealized appreciation. That is, it's going up in value, I'm not taxed. And that stems from a 1918 case called Eisner against McComber. It's been part of the tax from the beginning. If I hold it for a long period of time and sell it, I'm going to be taxed preferentially, probably. It's going to be a capital asset in my hands, and so I will be taxed on that as long-term capital gain. Those two features are an enduring part of the law. They're just there. There have been suggestions about changing them. I'm not sure they're ever going to change. The important part for purposes of thinking about the charitable contribution deduction is that when you make a charitable contribution of long-term capital gain property that is appreciated, the gain on which would be taxed as long-term capital gain, you get a deduction for the full fair market value of the property transferred. All right? So what that means is that, in effect, you're getting a double benefit. You're getting the value of the contribution deduction, and you never get taxed on the unrealized appreciation. And I can tell you that there are very few areas in the federal income tax where you get that sort of double benefit. So it constitutes a very high-powered incentive for charitable contributions. But once again, it's not peculiar to conservation easements. It is true of charitable contributions of long-term capital gain property generally. And I can remember Kingsbury Brown asking me when we were debating these issues, he said, well, you know, isn't the real problem the appreciated property rules? And I would say, well, to some extent. And he'd say, well, if that's the issue, why don't you deal with that? And so there was an unstated parenthetical at the end of that, which is good luck with getting that changed. It's not going to change. All right. So the question is there anything special about charitable contributions of conservation easements given these other two considerations? And from the Treasury's perspective, the answer to that question was yes, there is. And the argument goes something like this. In general, to get a charitable contribution for a charitable deduction for a contribution of appreciated property, the statute requires that the taxpayer contribute their entire interest in the property. It has to be given lock, stock, and barrel. And if you think about it, when that happens, that is, if I give some appreciated stock or I give an appreciated piece of land to a charity, if I give up my entire interest, at least you know at the end of the day that the value of what I give up and for which I'm claiming a deduction is equal to the value of what the Treasury gets. Okay? I mean, not the Treasury, equal to the value of what the recipient gets, because they now have the interest in the property. They are, in general, free to do whatever with it that I would have done. So you know that the value on the two sides of the transaction is the same. What happens when you are talking about contribution? I mean, for that reason, there is this general prohibition against the contribution of partial interests in property. There are three. Before the conservation easement legislation, there were two. There are three exceptions to this partial interest limitation. One is that if you give a remainder interest in a personal residence or a farm to a charity, you can take a deduction equal to the fair market value. The second is that if you have a piece of property, you can give an undivided fractional interest in the property to the charity. That is, if you own a piece of property, you can give 1/5 of it or 1/2 of it, creating an undivided interest in the charity in that piece of property. In both of those cases, something transferable of value has passed from the donor to the charity, so that the restrictions are fairly limited. The deduction for conservation easements is the only form of contribution of which I am aware in which what is being contributed to the charity even though it is dignified, however it may be dignified under state laws and interest in property, is essentially just a restriction enforceable on by the charity on the use that somebody else can be made of the property. That is, it doesn't confer an interest that is possessory or is going to become possessory. It doesn't confer an interest that is transferable. So it is qualitatively different from anything else for which a charitable contribution deduction is allowed. And it is that fact that underlay the fact that the Treasury sort of had reservations about this legislation. So it seems to me that three things follow from this characteristic, this sort of unique aspect of this. Number one, since it takes the form of a restriction on property owned by somebody else, you need somebody around to enforce the restriction, and the enforcement has to be in perpetuity, and Nancy has already spoken to sort of the difficulties that are entailed with that. You just need to think about the slide she had up about all the requirements relating to the protection of this in perpetuity, this interest in perpetuity, and that will tell you something about the difficulties that are involved. The second is that since there is just a restriction that's being transferred, not really an interest that's ever going to become possessory, you have a lot less reassurance or assurance that the value of what the donor claims as a deduction is equal to the value of what the recipient gets, is equal to the public benefit, whatever public benefit there is from the contribution. So there are these two qualitative differences. And then the third, and I think from the Treasury standpoint, the most important difference is that the problems of valuation are especially acute. For all other valuation problems, including the other exceptions to this partial interest rule, essentially the valuation difficulty begins and ends with estimating the current fair market value of the property. And that is generally defined as the price at which it would change hands between a willing buyer and a willing seller, neither being under a compulsion to buy or to sell. Now, sometimes that's not so easy to do, but it's basically the only valuation decision you need to make. Even with the other exceptions to the partial interest rule, that is a remainder interest in a personal residence or a farm, or an undivided fractional interest, once you've estimated the fair market value of the property, you're pretty much done. You can discount to present value the remainder, you can divide the appraised value by the fractional interest, and you have the number that you're going to use as a contribution deduction. With a conservation easement, on the other hand, you need two valuations. The first is the fair market value, although I put an asterisk beside that. The fair market value is the date of the contribution, and the second is the value of the land as burdened by the easement, and that second bit of valuation is essentially speculative and very hard to come by. And very frequently, when you look at the valuation cases, and there are a lot of them, I'm thinking I was sort of educated about this by Karen and by Nancy in the last couple of days. You look at the valuation cases, and many of these involve appraisals that have a before value. It has no relationship, no obvious relationship to the actual fair market value of the property at the date of the contribution. So I would say, and I think the Treasury was apprehensive, although their apprehension was probably not as pointed as I have articulated it today, there was apprehension that the allowance of deductions for these sorts of contributions would raise valuation issues that were particularly, almost uniquely difficult in the area of charitable contributions. And so it was that basically led to the Treasury sort of opposing the legislation. As everybody knows, the Treasury's objections were noted. Congress went ahead and passed the legislation, and you've now had 30 years of experience with all of this stuff. I guess I would end with sort of three questions and a couple of observations. The first question is, are the concerns that the Treasury articulated then 30 years ago, would I regard them as having been well-founded? Well, from my perspective, just as a sort of a disinterested academic, I would say yes. That is, there are these difficulties with the perpetuity requirement, what Nancy refers to as the elephant in the room. The enforcement, about which Karen's going to speak in a moment, has been very costly and very time-consuming for the Internal Revenue Service. And the valuation difficulties are sort of almost inescapably acute. That is a source of serious problem. Okay, so let me close with a couple of observations. I basically sort of come down thinking that Treasury was on sound ground to be worried 30 years ago. There's plenty of room to be concerned now. Okay, so what I'd like to do is to think for a moment about reform. It's what Roger's going to talk about, so I don't want to sort of get very deeply into it. But I want to sort of put on an economist's hat for a couple of moments, and just sort of hypothesize, and this is the way an economist would model this problem, that you could imagine out in the world that there were two distinct classes of conservation easements, okay? There were a class of good conservation easements. You can each of you pick your favorite example, but it's an easement that protected a really undeniably legitimate interest. The easement was given to the most diligent of recipient organizations. The valuation was impeccably done. Nobody, essentially unassailable. If you ever find an unassailable valuation, I don't know, but let's assume it's unassailable. You have a paradigmatically good conservation easement. And then you have the class of paradigmatically bad conservation easements. And again, reading the cases, you could figure them out. Having read a few cases recently, I would guess White House Hotel and Boltar would be pretty good exemplars, one involving a facade easement and another involving open space. So you have a class of bad easements. If you were thinking about this problem in that way, what you would want to ask is there some mechanism by which you could get these things sorted out in advance? That is, create incentives to encourage the good stuff and create penalties that would discourage the bad stuff, and in a way in which you could do so without expending the resources that Karen is going to tell you that the IRS has had to expend. Now, I don't know if there's an answer to that problem, but it's conceivable that there is. You formulate the problem in that way, and an economist will say, well, that sounds like a signaling model or a screening model. So maybe there's some mileage to be gotten there. I don't know whether you can get there. My final thought is this. In doing the reading that I did to prepare for today, one of the things that had occurred to me at the very beginning of this sort of revisitation was that all of these things ought to be registered. And then as I was doing some reading, it turns out that there are registration statutes. You're going to hear about one in Maine today. There is a movement toward national registration. I would say that any effort to really try and control what's going on in the conservation easement area would start with a national registration requirement and a requirement that to get a deduction for a charitable contribution of a conservation easement, you had to register it with the national database. Okay, so I will stop there.